And we are so very, very excited to have with us today Matthew Hoeg from CSA San Diego County. CSA San Diego County is an organization whose primary mission is the promotion of social justice and public welfare through programs, services, and advocacy against all forms of discrimination, including advocacy for the eradication of housing discrimination to assure equal housing opportunity for all individuals. As always, the purpose of the series is to provide tips for parents and individuals with disabilities, and Matthew will be sharing the ways in which CSA San Diego has been both supporting and assisting members of the community through their commitment to promoting and enforcing fair housing laws and equal housing opportunities for all individuals who live in San Diego County. I want to have you all to give a COVID clap to Matthew as he joins us.
With that, thank you so much to Melissa. I'm so excited to be part of this project that A Better Life Together and the B.R.I.D.G.E project specifically have been working on, really in terms of thinking about getting past the no that we know so often exists. So I know Melissa and I, we've been chatting back and forth for quite some time now, and I'm so excited we've been able to work together in a number of different ways. So this is really exciting for me to be here. And especially on behalf of CSA, I know right now there have been a lot of questions about housing and what that means. Our focus is really on the discriminatory practices and making sure those are not happening. With that, CSA has been around for quite some time. We actually started off as the Center for Social Advocacy. Now it's just become the CSA. We oftentimes get that question, but really our goal is to focus on a number of different issues, including hate crime prevention, civil rights for first-generation immigrants, human trafficking, youth education, and civic engagement. So we do have our hands in a number of different pots. Obviously today, we'll be talking about housing discrimination specifically. So really our mission statement at CSA is to eradicate housing discrimination. And we do that through a number of different ways. We have a number of different grant projects through the federal government that we work with, including what's called a FIP grant, which basically means we have kind of some investigative, we want to investigate some cases of what's going on, as well as outreach projects. And then all of our services are free. So anybody can call in if they feel they've been discriminated against, and we can conduct that investigation and really see what's going on, what evidence is available, and help that person file either through the federal government or through the state. And we'll talk about kind of the differences there a little bit today. But really, we're just committed to ensuring equal housing opportunities for all. We know that that has long not been the case, and it continues today. So we want to keep an eye on that. We want to stay vigilant and really bring up and hold accountable where those discriminatory practices are taking place. So we'll start off talking about the federal fair housing laws, then we'll jump into a little bit of state, and then we'll talk about some protected classes that are specific. Obviously thinking about disability as a protected class, race as a protected class. We'll also touch on source of income and familial status, which are important ones, I think, in conjunction with a lot of the ways discrimination is occurring. Throughout, I'll be talking about how COVID is affecting some of these issues. And at the end, I want to make sure we touch on the new eviction protections, just make sure we kind of disseminate information about what that means for tenants as well. So HUD is the Housing and Urban Development. Obviously, they work a lot with us in terms of making sure that we are investigating these types of cases. So they're really our primary grant fundee through a lot of these housing counseling programs that we work on. And so they're really an important agency. We also work with the state as well on those levels with the Department of Fair and Equal Opportunity. So with the federal protections, there was the Fair Housing Act of 1968, which is a really important starting point, I think, for thinking about why it's important that we enforce this act. The act passed the committee just to get to the Senate floor by only one vote. So it took a lot of effort, not only the unfortunate assassination of Martin Luther King, but also the protests that really garnered out of that, and really pushed for the Senate to really move and take some action in enforcing some policies against discrimination. So with that, it took a lot of effort to even put into place the Fair Housing Act of 1968. And because of that, it's really vital that we want to make sure that it's being enforced. So often we see that policies are put into place, but the enforcement process is not always incorporated. So that's really what we want to do is make sure that we're looking at those places where discrimination is taking place, and really focus on ensuring that those protections are pursued. So there were some additional amendments as well, which included protected groups. The federal still uses the word handicap. We use disability and familial status, which were some of those additional protections, as well as gender, which became an additional protection later on. So starting off, I like to just talk about what is housing discrimination, just to kind of establish, I think we're all familiar with what discrimination is, but this definition is really coming in terms of what the law asserts discrimination is, which I think is important when we look at some of the things that are going on, and where that law is applicable. So housing discrimination includes blocking someone's access to housing, treating one renter or buyer differently, or denying someone the right to buy or rent a home, even though they can afford the property, all because that person is a member of a protected group or class. And so protected class really refers to a specific demographical identity. And so if the decision is based on that identigraphical identity, that's when discrimination takes place. These are just kind of listing of what those federal laws are. So the federal protected classes that are really listed under the law here, that I'm referring to in terms of those identifying traits, would be disability, race, sex, color, national origin, religion, and familial status. And so what's really key about this is that all of us have an ability, all of us have a race, all of us have a sex, color, national origin, religion, and perhaps familial status, right? Familial status and disability have some kind of changed protections, but essentially this law is applicable to any and all residents who are looking for housing or looking to be serviced by a housing provider. So these are the 7 federal protected classes. And again, we'll take a look specifically today at race, disability, and familial status. So these are the state provided protections. So you can see that the state has expanded a lot of these protections to include sexual orientations, gender identity, expression, marital status, source of income, which will be another one we'll touch on, especially now with COVID, citizenship, primary language, and immigration status, and veteran status. So these are all key components on a state level that really provide some additional protections to individuals. So if, for example, discrimination happened on the base of citizenship, we might be able to pursue the federal through the national origin, and then through the state level on the actual citizenship discriminatory practice. So there are some exceptions under the law for where there might be some maneuverability in terms of where the law is applicable. So the Fair Housing Act covers most of all housing practices. We can go back one. And so if for example, somebody is just renting one room in their apartment, they might have some room to say, no, I would feel more comfortable with a female because I am a female, right? So there are some kind of situations where the law may not apply as strictly, but the way I like to approach this is if something's happening and you feel it's discriminatory, give us a call and we can kind of see what's going on and where the law would be applicable. So these are just some examples of what we've seen in terms of discriminatory practices. Obviously, refusing to negotiate, refusing to rent a house or apartment to somebody on the basis of one of those protected classes would be discriminatory. Some of the areas where we see that there's some gray area, which we know is kind of how discrimination is occurring these days, is kind of falsely denying that a house is available, imposing different pricing. We see some sales that are up and then only applied to certain individuals. The use of different qualifications or criterias, discouraging rental, and then assigning tenants to specific areas, which we'll touch on a little bit when we touch on race. And then, of course, refusing to allow a reasonable accommodation or modification for an individual with a disability. So these are all kind of forms of discrimination that have occurred, just as some examples. The other important discriminatory practice that's prohibited under law is retaliation. So everybody has a right to inquire about whether they're being discriminated or not. So that means if somebody feels that they're being discriminated against, and they give CSA a call, and we see that there's merit to file a complaint through the federal office, that would then notify the owner of the property. And if the owner of the property then says, you know what, this person's too much to work with, we're going to evict them and push them out, that would be discriminatory action under this law. So whether or not that initial discrimination actually took place, if once they find out that this person is seeking information about their rights, is seeking information about what they can do, and then takes a retaliatory action against that person, that act in and of itself could be considered prohibited under the law. So it's important to know that tenants do have the right to seek information about what their rights are and to pursue those rights under the law. And that if they receive some type of action in contrast to that, any intimidation saying don't go or I'll do this, that can be considered discriminatory practices under this law. So we'll jump into race here as that protected class. The way the law is defining race is it refers to a family, tribe, or group of people coming from the same common ancestors. Some race categories that often come to mind are white, Caucasian, like myself, Black, African American, Asian, American Indian, Alaskan Native, Native Hawaiian, Pacific Islander. There are also mixed racial groups within these categories, and the law also covers colorism that might be occurring. And we do see that sometimes. So it's important to kind of think about how the law approaches race so we can understand where those protections will be applied. We know that redlining has existed and was institutionalized after the New Deal. And with that, obviously the institutionalization on the federal government took the redlining practice away, but the integration of that redlining has really contributed to segregation of our neighborhoods and the continuing practice of what we now refer to as steering. And so this is where if somebody is applying to an apartment complex and wants to know where all of their buildings are at, the property manager might say, well, we think you might be more comfortable in this particular building because there are other African Americans in that building, or because you're Vietnamese and we think you want to be with the Vietnamese community. That would be considered steering. And it's important to remember that the individual family or persons renting need to know all of the options available so they can make their own decision about where they want to live based on their income. And so that's where it becomes really important that this steering has really contributed to the continuation of these redlining practices. And so if you feel that you're kind of getting the runaround and a person is pushing you towards a particular area on the complex, pushing you towards looking for housing in a particular zip code, that can be considered that steering practice, and it's worth looking into to see what's going on. With that, there are some other instances of discrimination that we know have occurred and then have been exacerbated because of COVID. So we've seen a number of harassment cases even before COVID where other neighbors might be harassing an individual saying, you don't belong here. That's where we see that kind of block busting practice occur, really trying to push individuals out of a neighborhood through that harassment. If you're on an apartment complex and experiencing harassment, if you let the property management know, they have an obligation then to really take care and make sure that you're not being harassed on the property that you're renting. So that's really a key component, that you have a right to a harassment-free environment, essentially. And so I have seen cases where a Black tenant was living upstairs, a white tenant was living downstairs, and they were both calling the police on each other, really kind of escalating some situations. And the property manager only listened to the white woman downstairs, but did not listen to the Black woman upstairs. And the Black woman was saying that the white woman downstairs was using racial slurs. She was waving the Confederate flag, really trying to intimidate and harass this individual. And the property manager neglected to address that situation, and that was considered discriminatory under the law. And so the property manager really has that obligation to ensure that residents are free of harassment in their home. We've also seen an increase in hate violence with COVID. We also see that some people are refusing to rent to certain populations. This is predominantly with Asian Americans under the guise of, oh, you must be bringing the COVID virus into the apartment complex. We don't want to do that. That is discrimination because you're making an assumption based on somebody's race. We know that evictions have primarily been focused on the African American community, on the Latino community. Even amidst the eviction protections, we know evictions have still gone through. And we've seen that they've gone through because of, quote, technicalities, because of kind of an apartment manager finding other reasons to evict somebody besides non-payment of rent. And so these situations really bring into question, why is that eviction taking place? Is it based on race or something else? Is it a health and safety issue? And so that is what we're seeing in terms of COVID. But essentially, individuals should not be evicted because of their race. I mean, that's really what it comes down to. And what I would encourage you all to think about is that sometimes we see where an individual feels that something is off, but they can't quite articulate it in terms of, you know, what's going on. And that's where I would say, if something feels off, give us a call. We can take a look and see what's going on. Because we see that discrimination these days is often taking place through those implicit ways without saying, you know, because you're Black, I'm going to evict you, right? They're finding other reasons to kind of implicate, okay, this is based on race. So that's what we want to keep an eye on. Source of income. So source of income, this is a state protection that's in place, and there are also additional protections in various cities throughout San Diego County. So anytime this one comes up, we want to kind of initially think about this, as any type of income that's a lawful and verifiable income. So for example, if I'm receiving disability and I am trying to pay my rent with disability, that's a lawful and verifiable income that I'm receiving on a consistent basis, right? And so a landlord would not be able to say, well, because you're receiving disability, we can't rent to you. That would be discrimination under the source of income clause. We're also seeing this in terms of the Section 8 vouchers, that Section 8 vouchers should be able to kind of apply anywhere. And really, unless it's verifiable income, you know, the property manager would need to accept what's going on and where that money is coming. So with COVID, what we're seeing is that a lot of people are seeking additional support from various agencies. We know that the CARES Act money is coming through. One thing to keep in mind, just as a side note, is that starting in March, those applications for the federal funds should be coming through to apply for rental assistance. And there are some nuances with that. And I'm curious to see how they play out with this source of income. But essentially, you know, things are rolling out now with new policies statewide, nationwide, et cetera. So there may be some complications that arise with this source of income. But essentially what I would say is, if you're trying to pay with some type of supported rental assistance and the landlord is not accepting it, give CSA a call or call the agency that's providing those funds to kind of navigate that situation and make sure that you're able to stay where you're living. So with that, we're seeing that they're refusing to accept those third-party payments. They're refusing to accept housing vouchers if somebody's recently recovered from COVID, or seeing a refusal to allow prospective tenants to use subsidized programs and to pay for moving expenses. So we're seeing a number of different source of income issues come up. But essentially, if you're receiving additional income from one of these verified places and the landlord is not accepting it, there could be some questions occurring there that we want to look into and make sure that discrimination is not occurring. All right, so familial status. This is another one that I think is important to think about, especially in relation to source of income, race, and as we'll talk about, disability as well. But essentially, when we talk about familial status, we're talking about families who have individuals in the house who are under 18 years of age. So what's important to remember here is that Oftentimes we see families who maybe an aunt or tia or grandmother is taking care of the children and the parents are not in the house. And if that's the case, the adults in that house are the legal guardians of those children and would be protected under this familial status. So familial status is not just directly related to parents and child relationship. This includes if the aunt is adopting their nephew, those would be protected under this familial status clause. So that's really important to remember. Additionally, if a woman becomes pregnant, adding to expanding the family, or otherwise securing through kind of legal means, adopting a child, or going through a foster program, all of those would be protected under this familial status. So what we see often with familial status is that property managers will create unreasonable rules that are specific to children. And this would be things such as, children cannot play outside during this time, right? And so that is a rule that specifically targets children rather than saying, please keep noise conduct in mind between 8 p.m. at night and 7 a.m. in the morning, right? So the noise clause applies to everybody rather than specifically the children. So if you're concerned about noise, don't make a rule that specifies children, right? Oftentimes we see that they'll create these rules and then give violations to families who have children and then threaten to evict them for violating those rules. But if the rules are specific to children, then that becomes discriminatory against families with children. So it's important to think about that if there are individuals under the age of 18 and there is some applicable rule or steering, we do see steering oftentimes with families saying, oh, we only want children on the first floor or only by the pool area, that can be considered steering and discriminatory. So if something is happening with the rules or there's kind of more bump-ins with children, or you notice children are not on the property, right? That can be a question of why is that and how is that occurring? So that's really familial status. If there are questions around that, let us know. We want to take a look. All right, so we'll touch on sexual harassment real quick then before jumping into disability, because we are seeing an increase in sexual harassment, especially with non-payment of rent. It's sexual harassment. There are two clauses here under the law in terms of what might consist of sexual harassment. And this is kind of a more complex breakdown, but essentially we have the quid pro quo, which is if you want to stay in, just as an example, right? So when we think about the quid pro quo, it would be the pressure to perform a particular act in order for X, Y, and Z to happen, right? So that kind of withholding of, maintenance in order for, a maintenance person's request for sexual favors, right? So that's an example of what we're seeing with the quid pro quo in terms of sexual harassment. So when any individual has a right to live free of this type of quid pro quo sexual harassment, that really the relationship between a resident and a landlord should only and ever be, I'm paying rent to stay at this place and make sure it's a safe and habitable environment, right? So any implication of sexual favors, sexual acts that would detriment that relationship would be a question of sexual harassment that we want to look into. Now, when we talk about hostile environment harassment, this can include a property manager consistently asking out a tenant and the tenant saying, no, I don't want to do this. This is kind of, you're harassing me and sending me these lewd texts that are really uncomfortable. It can also include if another tenant on the property is making lewd comments or kind of encroaching on an individual's personal space, touching them in unwelcome ways. The person who is being assaulted in that sense has a right to not only contact the police if it's severe in that sense, but also let their property manager know. And the property manager has a duty and obligation to make sure that that type of harassment is not happening by any other tenants on the property. And so this is really important to think about when we talk about the harassment can include not only sex, but also race or disability. That if that type of harassment is occurring, the landlord has that obligation to make sure that it stops and ceases and to ensure that that is not an issue for a person living on the property. All right. Obviously, with COVID, unfortunately, these types of questions have increased. We've seen this especially with the quid pro quo because a tenant's unable to pay rent, where a landlord might say, "Well, you haven't been able to pay the last 3 months of rent. Maybe we can figure something else out." And anytime they say maybe we can figure something else out, with the implication being sexual favors, sexual acts, going out on a date, something even as simple as that. Um, can be considered this quid pro quo sexual harassment, right? Because it implies that the sexual favors carry weight into whether a person would feel comfortable in their housing, and that's what we want to make sure is not occurring. We've also seen hostile and pervasive sexual harassment, um, threats of eviction for failing to submit to such acts, and it's important to note that even if those acts are negated and said, no, I don't want to, or even if they are submitted to, there's still recourse through the law to make sure that there are protections and that those protections are upheld. Sometimes we often see where a property manager or maintenance person will enter into the property without 24-hour notice and do that kind of consistently, trying to put that person into a position where they might feel really uncomfortable, especially based on their sex, etc. And then shutting off services or withholding repairs because they're not submitting to the harassment. Really, there are a number of different issues that come up when we talk about sexual harassment. But again, if something is feeling uncomfortable, if something is feeling off on this basis, that's when we want to take a look in and really see what's going on, and really make sure that sexual harassment is not occurring. Okay, so let's go ahead and jump into disability, and we can kind of think about, I like this image before we jump to the next slide. I like this image because it really demonstrates how ableism is really infused into the construction of our homes and the construction of our apartments, really into every aspect that we do. And it's important to kind of remember that if something is built incorrectly based on somebody's ability, that there are workarounds to make sure that that can be accommodated and modified. So when we talk about disability, we're talking about both physical and mental disabilities, a disability, and this is kind of the legal definition of how the legalities are surrounding disability. So it may be a physical or cognitive or mental or sensory, emotional or developmental, or some combination. It can also include chronic diseases such as diabetes. An individual might also qualify if they have an impairment in the past that might be seen as disabled. Again, it's kind of really any physical or mental impairment that substantially limits one or more major life activities, right? And that can come into play in a variety of different ways, where an individual might have difficulty walking long stretches, right? That our ability to really navigate a space might come into play in terms of how we're expected to navigate a space. Or it might include somebody who has an emotional support animal, which we'll talk about as well. The disability clause also includes individuals who are recovering from drug or alcohol addiction, and really in that recovery process, they're covered under these disability clauses as well. So any individual with some type of impairment according to the law would have the right to make those reasonable modifications or accommodations in order to get the full use and enjoyment of the house, just like any other tenant on that property or any other person living there. And it really protects buyers and renters. So again, if you're in the buying process of a home, you want to make sure that you're able to buy something that's comfortable for you, and again, make those decisions about your property that any other buyer would be able to make. This also applies to anybody associated with a person who is disabled, right? So if, for example, I'm working with, I'm looking for an apartment and my brother has a disability and we're both moving in together, and they find out my brother has a disability, and then all of a sudden, somehow, some way, this apartment has been taken, right? That might cause me to question, is it because they found out my brother has a disability, right? And those are the questions that we really want to investigate and look into, that me being associated, that might have perturbed my ability to seek housing, right? The other aspect here is that any person who's perceived as disabled would be protected under this clause. So if a property manager is thinking that, oh, well, this person, they have a mental concern that, is preventing them from doing X, Y, and Z, and therefore they discriminate against this person, whether or not that person really has a disability, the property manager's decision was based on an assumption that this person had a disability, and that would be protected. So we'll start with reasonable modifications and then jump into accommodations. The difference being, so modifications are really changing the property, like I was mentioning earlier. If handlebars are needed in the bathroom, those types of kind of necessary changing of the structure of the property to make sure that it's working for the individual living there are really important and allowable under the law. So they must be allowed, and they're really those physical changes, again, to the property, and whether it's the common area or the private living space, those requests can be made. And again, the idea being to that full use and enjoyment of the property. So the other aspect here is that they must be reasonable. So for example, if somebody has an apartment on the second floor, but they have a chronic disability that is worsening, and now they need to they're unable to go up the stairs, they might request, as that reasonable modification, an elevator. However, that elevator might be unreasonable in terms of cost, in terms of construction, in terms of coding, etc. So the apartment manager might say, well, instead, how about we find you an apartment on the first floor? That would be what we call an interactive process, where they may not be able to grant that specific modification, but they're working with you to address the specific needs that need to be addressed. Just by making a request, a person cannot be evicted, and that property manager is required to engage in that conversation to figure out how best to modify or accommodate what's going on. So if there are requests made, it's generally at the cost of the resident. There are some exceptions, especially with HUD. And then as they move out, that person might be required to place the unit back to its original condition. However, most property managers say, you know what, the handlebars aren't really in the way. This is what we call curbism, right? Where curbs actually help everybody rather than just a select few. And so really oftentimes managers will leave those modifications in place rather than having an individual take them out. The FHA allows for a security deposit to restore the property back. It can't exceed the cost of restoration, and it must accrue benefit to the benefit of the resident. So just kind of some nuances there that come about. So if you have questions about requesting that modification, what that might look like, again, that's what we're here for, to kind of help navigate and facilitate that process. So we'll talk about reasonable accommodations. And again, this is separate from the modifications, because rather than changing the structure of the property, here it's more changing the rules, policies, and procedures that might afford a person with a disability, a disabled person, the full use and enjoyment of that property. So you notice we consistently use this full use and enjoyment of the property, and that's referring to a person with a disability has the right to enjoy the property just as much as anybody else living on that property. And they might need some removal of some impediments to be able to do that. So again, they might ask for exemptions from resident rules, from certain policies or practices, whether it's in the private living space or the common areas. However, if it causes that undue financial burden, that's where that interactive process would take place to say, well, we can't actually accommodate you in this particular way, but we might be able to do this, or let's have a conversation to figure out how best to address this. They're always required to engage in that process to make sure that you guys can come up with something that works to the benefit of everybody. The kind of general example here is a service animal, right? So if a place has a no pet policy, it's important for them to remember that service animals are not pets. They're a clear distinction, right? So that pet policy would not actually apply to a service animal, which we'll kind of delve into as well with emotional support animals. If somebody makes a request for that accommodation, again, they can't be evicted, but they would have to navigate and negotiate that process to figure out what works best. Sometimes there might be administrative fees, but the housing provider on the accommodations is required to pay for those fees. So this kind of just breaks down what that accommodation process looks like, in terms of kind of the specificities of it. It might be a change or exception or adjustments to some of those policies, so it doesn't always have to be an exemption. It might be a change to, maybe there isn't a rule policy, but there's kind of a practice, right? A customary process that is gone through, but that puts that impediment to somebody with a disability. So they might be required to work around that. And we'll talk about some examples as well here in a second. But essentially, we also want to make sure that rules and policies aren't put into effect that have a different effect on persons with a disability, rather than those who do not have a disability. So they might have put in a rule that specifically targets individuals with disabilities, and that would definitely be a problem. We see that sometimes with the same way we see rules that apply specifically to children, rules might be put in place that apply to individuals with disabilities. And then, of course, persons with disabilities have a right to request that reasonable accommodation at any time. So even if they've been living there for 10 years, and all of a sudden, their disability has been worsening or changes, they can then request that accommodation. So a housing provider can request a verification of that disability. So let's say a person looks able-bodied, but they're saying, you know what, I have this medical condition where, I do receive disability, and it comes in on the 5th of the month. So can I pay rent on the 5th of the month rather than the 1st month, right? That might be their request of that accommodation. The housing provider might be able to say, well, you don't look like you have a disability, right? That question might come up. But the fact that they're receiving disability can be that verification that this person is disabled. But if, for example, the housing provider might be entitled to ask for a letter if they're not receiving disabilities, maybe it's some other circumstance, the housing provider can ask for a letter from their doctor verifying that it's a disability, but that the property manager does not have HIPAA authority, right? So they wouldn't be able to see the nature of the disability, what it's in relation to, et cetera. That letter would just say this person has a disability and is requesting this accommodation for X, Y, and Z, right? Those are the only two connections that need to be made in that verification letter, that a disability exists and that accommodation would address the disability. All right, so these are some examples of disability accommodations, reasonable accommodations that might come up. Again, changing a date that is due for rent. Sometimes an individual might have a cosigner that could cosign, or making certain repairs to a unit to accommodate a resident. Let's say that they are prone to they need the temperature to be a particular level in the apartment, and their air conditioner goes out, but it's important that they maintain that temperature, right? They might be able to say, look, I know you go down the list in terms of order based on when they're put in, but I do have this disability where I need this fixed right away, right? That would be an example of where you can request that accommodation. Again, smoke-free environments. If they need a few extra days to move out, they can always ask for that. The first floor unit, sometimes there might be only limited disability parking that's close to the front office, but the parking space for an individual is farther away from where their apartment is, but they could ask for the assignment of their parking space to be closer to their unit rather than having to walk that large space, or it doesn't include sidewalk or curbing, and so they might be able to request parking closer so they're able to use their mobility devices in a better capacity. Next slide. So when we talk about animals, the law kind of categorizes 3 different animals here. They categorize service dogs, which are, the most often example is a guide dog for an individual who might be blind, or for example, a Dalmatian who might notify the person when they're about to have a seizure. Those types of animals are really those service dogs that are there to perform a specific service for that individual. Now, emotional support dogs are in the secondary category, where they provide emotional support, as it is in the name, to an individual who might be suffering from their disability. And so with emotional support animals, There's often questions about whether or not they're allowable in public spaces, but in your home, they are required to allow an individual to have their emotional support animal there. So this might be a cat, this might be a dog, whatever that animal is. If it's an emotional support animal, an individual has a right to live with their emotional support animal. So a landlord cannot neglect a person's emotional support animal in that capacity. And then we have therapy, and then we have pets in another category, right? And so pets are not related to emotional support dogs or animals, and they're not related to service animals, right? Those are pets where a person says, you know, I want to have a dog, and they develop a relationship with the dog. That pet would be applicable to the pet policy. Now, sometimes there are questions where an individual might have a disability, but they don't necessarily need an emotional support animal or a service animal, but they do have a pet. Now, that pet would not be applicable under the service animal or emotional support laws, but it wouldn't be considered a pet, even if that person has a disability. So that's what's important to think about, is that emotional support animal or service dog or service animal is performing a service for that individual to make sure that they can enjoy their home. And that connection is what needs to be made when requesting this type of accommodation. All right, so with COVID, we've been seeing a number of specific issues because of COVID, and we can start with kind of thinking about individuals who might be perceived as having COVID, and then being neglected to apply for their tenancy or move in, right? That might be considered protected under the clauses here. Now, it's important to remember that if an individual does have COVID, COVID itself is not considered a disability. And this is important because if somebody's only sick for a couple of weeks with COVID and trying to quarantine and stay safe, right, that is not the same as a lifetime impairment. And so that's an important distinction. However, we are seeing some long-term effects of COVID that might develop into an impairment on a daily basis for a person. And so that's where that disability clause can come in to protect that individual, to say, look, because of COVID, I'm now having breathing issues and I need to move into an apartment that is smoke-free, right? Or that's away from these apartments where there's a lot of smoking going on. Something to that effect might be considered protected under these clauses. We're also seeing persons who have disabilities who are being discriminated against because a property manager they may be requesting additional protections, right? Saying, look, I'm more prone to COVID. If I do contract COVID, this could be a more dangerous for me than maybe some other individuals, and therefore I need to hold off on this particular maintenance until I'm vaccinated, right? That might be something that's important for a reasonable accommodation request that can come through, right? And somebody would have that right to say, look, I know that my sink isn't quite working. It's functioning for now. Can we please avoid having this repair made until I'm vaccinated? That's a reasonable accommodation that can be requested. So if there's some question coming up between disability, COVID, and somebody's ability to enjoy their home, that's what we want to look into. So these are just kind of some quick bullet points, again, about kind of disability and COVID. We're also seeing an increase in harassment of individuals with disabilities. Again, hate violence, certainly not something we want to be seeing, but it is happening. And so when that happens on a particular apartment complex, that's what we want to look into to see if that fair housing laws, to see if those fair housing laws can be applied and ensure there's some accountability there. Refusing to rent to individuals with disability for fear of any liabilities, that's considered discrimination. Evictions, right? Certainly discriminatory if it's based on a person's request of an accommodation, request of a modification, or based on perceived or actual disability. Refusing to grant those reasonable accommodations would be questions that we want to look into. So what happens when a case comes through? We would take a look at it. If we do find that there's enough for a complaint to be made, or we're unable to kind of mediate that process, sometimes an individual will say, you know, I'm requesting this accommodation, they're not giving it to me. We send our legal counsel letter to them, and that property manager says, oh, okay, this is a legal matter. Maybe I do need to grant that accommodation, right? So maybe we're able to resolve it in that sense, all the better. However, if we're not, and we feel that, and the person wants to file an official complaint, we would do that through HUD or the Department of Fair Employment and Housing through the state office. And they would conduct an investigative process where they ask everybody for documents and take a look at what actually happened and see if the law would apply in that sense. So it's always to the benefit of even the property manager, the landlord, to allow a complaint to go through that process. Other COVID resources, obviously 211, California Department of Public Health, Center for Disease Control, and San Diego County are all important resources. We often get the question about where to call to find out about rental assistance. Our office, we only had programs to provide rental assistance in Santee and El Cajon, and both of those programs have now closed out. However, as I said, there are additional federal fundings coming through for rental assistance that do not apply to immigration status. They are for anybody who is behind in their rent because of COVID reasons. And so those will be opening up come March. As far as which agencies will be distributing those funds, that has yet to be determined. And the best course of action is either to call 211, but the better aspect might be to actually call the direct city that a person is living in. So if I'm living in National City and I'm behind on my rent, I would call National City and they would direct me to if they themselves are doing it or if they've directed those funds to a separate agency to distribute. So that's kind of the best process to find out about where rental assistance is coming through. However, if then you obtain that rental assistance and the person decides that they don't want to accept it or etc., then those might be questions we want to take a look at. Like I said, with the new policy that was just implemented, the COVID Tenant Relief Act, a landlord does have some options in terms of whether or not to accept the 80% or just 25%. But either way, they might have to accept some of those funds. So if there are questions about that, give us a call. We'll take a look. So here's our contact information. Again, we'll send it out as well. But essentially, what I always like to say is if something feels off, if something feels weird, give us a call. We want to take a look. We want to investigate what's going on. Is it based on a particular protected class, or is it simply something else that's going on, just a miscommunication? We do see that sometimes where there's a miscommunication occurring. And once somebody calls our office, then we can kind of step in and mediate and facilitate that communication process to the benefit of everybody. So really we're here and we want to take a look at those issues, make sure that we can address what's going on. Before I close out, I know I'm probably really pressed for time here, but I do want to make mention of the COVID Tenant Relief Act that was passed at the beginning of February 1st. And it, on a state level, extended the eviction protections through June. So what that means is that tenants cannot be evicted for non-payment of rents. So certainly if they've violated a serious safety issue on the property, they may still be evicted. But if it's because they haven't paid rent, and they're unable to for COVID, there's a specific process that they need to go through to ensure those protections. And this is what I want to emphasize, that there are specific paperwork that need to be filled out, and that if one of those pieces is not filled out, we're seeing that those landlords are really trying to fudge and maneuver to make sure they can evict people. And that's what we want to make sure is not happening. So if somebody's in a precarious situation and they're being threatened to move out, and so forth, give us a call. We want to work with that person. We want to make sure that they're able to stay in their home safely through June, especially if they have a disability. They might be in a certainly more precarious situation. We want to make sure to address that. So certainly, if there are questions about that policy, what it means for that person, give us a call. We're always concerned about making sure people can stay in their homes. All right. So with that, I'll open it up to questions and see what I can help with. I know we went over a lot of information, so.
Good morning, Matthew and everyone. I will start off the questions. So a lot of times, Matthew, the agencies are supporting individuals with disabilities in their homes. And a lot of them, one of the mantras is they should have a right to live in their own community as they see fit with our help. So one of the things a lot of times our staff run into is landlords not understanding. So if you have an individual that may have a dual diagnosis consisting of maybe schizophrenia as an example, there are sometimes some actions. Are there things that you have or areas of your business that can help when we are trying to make sure landlords basically are educated on what happens? Because we are there to support them. So if something occurs, they could actually call us and we can come in and help maybe diffuse some things, but sometimes they just don't know. Can you speak to that at all?
Exactly, and that is an excellent example of the types of, I'm hesitant to use the word gray area, right? But where a property manager is not familiar with where that law applies, right? And so that's a really key area that we want to make sure we're addressing. So if a resident has a resource such as you all, A Better Life Together, right? An excellent resource in making sure they're able to navigate those situations, it may be helpful for the property manager to know this person has a disability and they're utilizing this resource. So if this resource comes in, right, that's who they are, that's what they're doing, and that this person has a right to utilize that resource to make sure that they're able to remain in their home and enjoy their home in a calm sense, right?
Yes.
And so that's a really key area, and we can help with writing that letter, right? We can have our legal counsel set up and or even just one of our housing counselors to step in and say, look, this person is requesting this specific accommodation. They do have a disability. You don't need to know what it is, right? But they do have that disability. And because of that disability, they're utilizing this resource. And so periodically this resource might come in to do X, Y, and Z. They might be there. So if you do see them, be aware that they're here for this specific reasonable accommodation. So we can help in terms of drafting that letter, communicating to that landlord, this is what's going on, and make sure you don't infringe on this resident's rights.
Okay.
Yeah, certainly.
I'm helping Melissa with the questions. So if you want to put something in chat, or if you want to just raise your hand or unmute, feel free to go ahead. Rebecca?
Yeah, hi. It's kind of a comment. I'm so glad that you guys have this. And if it's possible, are you able to share the slides for those that attended for our reference? That would be wonderful. If not, I don't know, maybe email us some of, like the information you shared at the end. But I wanted to say that thank you. I was not familiar with that term. Is it streaming? That was up there because I have personally experienced that. I'm in affordable housing. And just to make it just an example of my son, he's a client of Regional Center. He has a disability, but to make our experience real quick, not to take too much of your time, when we first moved into affordable housing, it actually took me 10 years to get in. And then I find out later how people were working the system, which was very disappointing. But anyway, I got him a basketball hoop, put it outside. Of course, I understood the laws about having it parked, having that hoop in my parking area, designated parking area. It's kind of like as if I was putting it in a red zone or something. So we were forced to get rid of it. Then I moved it in front of my garage. Then I started getting these letters saying, if you do not get rid of the basketball hoop, and I also have a letter from his psychologist saying he needs this for social, to help his socialization because he's on the spectrum of autism. Anyways, I started getting harassed, got all these letters saying if I do not remove it, that I'll be forced to move. I'll get like a 30-day notice, a 3-day quit, whatever it is. I saved all my documentation. I'm a paper hoarder. I saved everything.
That's excellent.
A year later, an attorney from I don't know where represented all the clients who have been harassed and forced to get rid of toys if you were not allowed to play outside, just like your slide described. Mm-hmm. And each person was granted automatically $3,500 living in each household.
Wow.
But you know what? Now I see all these basketball hoops all over. It's disappointing. My son's 19. Money cannot replace that experience for someone on the spectrum.
True.
It's so sad, but save documentation. That's why I want to share this. Make sure now I'm a social worker. I work in hospice, and people in hospice can't save documentation. They don't have access to like technology like we do. I have a patient. She is being discriminated. She's bedbound. She has an IHSS worker, and I'm hearing things how she's not allowed. She's renting a room. She's not allowed to utilize the kitchen. So, and I'm gonna call her today because she's not a morning person about the Great Plates, meals that we have. But when I first heard that and looking at the slides, I'm thinking, wouldn't that be considered maybe discrimination? And I don't know why they're not allowing her to use a kitchen, but she is a tenant, she is paying rent, she's renting a room. Is that something like?
So yeah, what we can do, the best course of action is, I want to address this particular situation and touch back too with a couple of things you stated.
Certainly.
Thank you. Yeah. So with that, it depends on a number of things. So the best course of action might be to contact one of our housing counselors to really gain an understanding of what's going on, right? We are seeing that some apartment complexes are closing some facilities to all of their residents, right, due to COVID. And so that might be something that, would be a health and safety issue for all residents. But if it applies to only particular residents, that's when we want to have a concern, right? And so that's kind of a question that might come up. But the best course of action would be, again, and kind of pulling back to one of your earlier points about keeping documentation and the difficulty of knowing what documentation to keep and being able to do so. By contacting one of our housing counselors, you can kind of start to understand what the law would be looking for, what types of documents to keep, and how best to keep those. That's really what our housing counselors are there for, to help guide through that process. If something's off going on, right, knowing what to look for is something that, one shouldn't have to do, right? But unfortunately, that
Absolutely
falls on the tenant. So we can help in that process and make sure that, residents know, okay, so this is happening. What should I start keeping track of? Okay, so the maintenance guy comes in before that 24-hour notice, or even giving that 24-hour notice, saying, well, saying some comments, right? Writing those down, recording those. We can help a person think through that process of what that type of documentation would look like.
totally makes sense. Thank you. Yeah, I keep forgetting about the COVID. We've been in this for so long, but that totally makes sense. Yeah, because due to COVID, and certain places are limited. What do they call those? The certain areas of a home?
Community areas?
Yeah, the community areas, they could be, yeah. But they can also be accommodating, like have certain hours, designated hours, something like that. I would say they could be accommodating to the individual as well.
Yeah.
Right. That would be one question. Go ahead, Clyde. I'm sorry.
Well, I was just going to add to Rebecca. I wanted to answer your question. Melissa answered it in the chat, but yes, the video will be rendered in a day or so, and the slides will be up on our website events page, and you can go back to those. You can always call and get them from us. I'd want to just add a couple more things. I'd love to have your story about your son with the basketball, because Melissa's going to be doing more and more of these and different forums, like parenting forums. So I'd love to have you there. That's just my plug to get your help.
Absolutely.
So,
yeah, feel free to, my email, it's real easy, mom, M-O-M, 92129. I used to live in the Penasquitos area, and then now I'm in the 92130.
okay.
But mom92129 at Yahoo. Yeah, feel free, have my permission to share that.
Okay.
And then, there's been other things too. You can always follow up with me and have a phone call with me, but there's been other things too that have happened, but that was one of the biggest things.
Okay. And so I want to add industry specific too. I'm sure you probably heard about HCBS. Or if not, it is a policy and regulation that right now only, I think, California and New York are exempt from because of some of the other things we have in California. We have the Lanternman Act, which provides the services in the methods that we do. But what HCBS says is that everything should be moving toward what's called person-centered. And when it's person-centered, if an individual lives in a group home, they should have access to have guests, to have access to every part of the group home. That is not the case today. And because of COVID, the compliance date deadline moved, which was supposed to be next month, to 2023. But that is The challenge with that is that there's going to be a lot of agencies that won't be able to be compliant. And so they're trying to give the opportunity, but just so you know, that is a directive, because it says that, you know, everything we do should be person-centered. So if I live in a group home and I want to have guests, then I should be able to. If I want to cook, I should be able to. And the only thing that interprets or would interrupt that, if any of that causes a health and safety risk to me. So just so you know, and those policies, they are in place, just not compliant ready in all areas. So that's where things are going to correct some of that stuff.
That's good to know. Thank you so much for addressing all of that. That makes sense. And of course, getting things to compliance takes lots of time and patience.
Yes, absolutely.
So one thing, thank you, Clyde, that's really helpful. And I think it'd be really beneficial, ideally, if we could build things people-centered to begin with, right? And kind of be focused on that at the get-go.
Absolutely.
That would be ideal. But I did, Rebecca, thank you for sharing your story again. And one thing I wanted to point out was that oftentimes if a complaint goes through, there may be some type of compensation that comes through for that particular complaint. And you're certainly right, Rebecca. The fact of the matter is that any compensation won't actually address somebody's experiencing going through that discrimination situation. However, you did mention that you now see basketball courts there across the board. And so I think it's important that when we think about filing these complaints, it's important to remember that we want to make sure this is not a recurring action. And that when those complaints go through, it really holds accountable those who are at fault with that discriminatory practice, and make sure that there are regulations that are enforced to make sure that that person is compliant in the future moving forward, so nobody else has to go through that experience. And unfortunately, that's kind of the way the system is set up, is that those who experienced it kind of have to put that foot down so that it doesn't happen again. But that's the way that the law is set up. So that's important to address. I also like the police box behind you. That's always exciting.
Oh yeah, it's my son who likes he's a big fan of that. Thank you again so much for having this. Appreciate it.
Yeah.
I don't see any more questions, so I will turn it back over to Melissa.
I just wanted to say thank you again, Matthew, for speaking with us today. I think we'd love to have you back later on in our Wednesday webinar series, just to talk in more specifics about a couple of topics. You and I have talked a little bit about that early on. And like Rebecca, I really didn't know that there was a term for steering. I didn't know that just someone suggesting, oh, you'll love this building over here. You don't want to be in this building. I had no idea. And so I think that there's a lot of people out there that may have no idea. So I'm very grateful for you sharing everything that you share with us today. And again, if there aren't any other questions, just as Clyde reminded all of us, this will be up on our website on the resources tab. There's quite a few videos from the series. We're going to be sure to also have the slides available for download. And then the video will also be available on YouTube. And there will be a link back to the website to download the slides from YouTube as well. But Matthew, just thank you again. Can we all do another COVID clap for Matthew?
Yeah, thank you so much, Melissa, for the opportunity to come in and share. I'm so glad to get the word out and so forth. So thank you. And certainly if anything else comes up, certainly more than willing to come in and jump into more specifics or whatnot. But yeah, thank you so much for coming. And it's all you all in terms of taking this information and spreading it as well. So really appreciate it. Thank you so much.
It's all a part of the bridge. All right, everyone have a wonderful day. If you have any further questions, feel free to reach out to me. You can reach out to me via the website. You can also ask your questions or anything that'll come up on our Facebook page. Make sure that you look at our posts from today and yesterday and follow CSA, and so you can keep up with all of the good work that they are doing, developments and updates to any new COVID developments where housing is concerned. That information is there on their page as well. But everyone have a blessed and beautiful rest of the day.
Thank you.
Bye,
Bye.
everyone.
Bye.